Mr. Estrada, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail. Looks like you guys have worked out an agreement where they're offering you 6 days in jail with credit for 2 on both of those cases. You need to understand that both of those cases will go on the record. They're going to be there for the rest of your life. You can never take them off. Do you understand? This is important because if you ever get pulled over, officer looks you up. They're going to see all the DWI. They're going to see the gun case. If they roll up to your car and it smells like weed, it smells like alcohol, what do you think they're going to do? Right. What we're doing today, from now on, you are facing a minimum of 90 days in jail. Do you understand? They can use these to enhance your punishment. You're looking at a minimum of 90. How do you plead to the offense? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, you can never change this. I take it the case upstairs is being dismissed?
Yes, sir.
Okay, what about the weapon? Okay, so the weapon will also be forfeited, meaning that you're not going to get it back. You understand?
Yes, sir.
I am going to suspend your license for 90 days.
Would you hear,
Drive until you get a license.
would you hear evidence on the surcharge?
Yes.
Judge, he's 20 years old. He works in a warehouse. He lives with mom and dad. He takes care of mom and dad. He helps pay for rent, pay for things around the house. He's trying to get his life together. His hours fluctuate between 20 and 40 hours a week, 40 on a good week, 20 on a normal week. He's 20 years old, just turned 21 now. 22, I apologize.
How much money do you make a month, sir?
900. Well, I would make 900.
900 every week?
Yeah.
You need to understand that DWI is big business in this country. What he's trying to do is he's trying to have me erase around $3,000 worth of surcharges that you would otherwise pay, not to mention court costs of another $400 to $500. So you could potentially be rolling out of here with around $3,500 in court costs. And if you don't pay it, you go to jail 1 day for every $100 you owe. So you could be doing a ton of jail time. You know, we're all allowed to make mistakes in lives, right? But the idea is that you don't continue to make mistakes where you endanger other people's lives. A second DWI, you're looking at surcharges of around $6,000. Do you understand? For $40, one button, an Uber will take you wherever you want to go. It don't matter how many beers, how many shots of tequila, take an Uber. Do you understand?
So,
All right, I'll waive it for you.
I agree.
This time,
Yes, sir.
well, that's it. You understand?
thank you.
All right, good luck.
Thank you.
Thanks, guys. What are the bond conditions that we have?
Judge, we have no contact whatsoever with Gracia Padron and Melissa Padron. We also have no drugs and no firearms, weapons, or ammunition.
So the assault is, who's the complaining witness in our assault case?
So on the assault here is Gracie Padron, and then the
You
felon.
know who that is in relation to this gentleman?
His partner's mother.
Yes, and then the partner is the complainant in the felony.
Hey, you're lucky to be out with as much baggage as you got, Mr. Warren. I mean, your history is just deadly conduct, unlawful carrying of a weapon, assault of a family member, violation of protective order, failure to ID, terroristic threat, violation of protective order, evading arrest, harassment, felony assault, failure to ID, criminal issue, violation of protective order, violation of protective order, and now a felony assault and another assault. You're laughing like it's funny. It's sad because all of these cases that you have, no self-control. You get angry, you wig out, and that's not the way we work, man. I'm going to protect my community at all costs, Mr. Warren. And if I have to make your bond $2 million, I'm going to do it in a heartbeat to protect my community. Do you understand? You have one issue. I'm going to keep you. That's it. I'm not asking for much, man. Just don't have contact with these people. Self-control. Do you understand? It's not hard. What do you do with yourself these days? Where do you work at? Are you working full time? Great. Like full blown like you're working 40 hours a week?
Yes, sir.
Great. That's good. I mean, I'm making that a bond condition as well. And when I'm working 40 hours a week, when you have too much time on your hands, you get self-destructive, man. You just need to occupy your time, make your money, and just move on. Don't have contact, don't have any weapons, and then we're cool. All right?
Your Honor.
You got this.
Respectively, due to the nature how it's continuously picking up the same complainant, we would also request GPS monitor to reflect the felony who have GPS monitoring on that for the same reason.
He has a GPS
So
monitor right now.
we'd want the bond conditions here to reflect that as well.
Is it through the felony court?
Yes, Judge.
Okay, so TAC Rs, you've got it on anyways. So know your every whereabouts. Don't go near these people. You got to charge it every single day, Mr. Warren. If you don't charge it, the battery's going to go dead. So does the bond. You understand? Okay, man. All right. Thanks.
Right this way.
Great.
May I approach? I'm doing well. How about yourself?
Does your guy have a BVR too? Yeah.
Eric Castillo, Judge.
What's going on with that?
On December 31st, it looks like she reported for
Positive.
positive for alcohol.
Is she here now?
She's in the box, Judge. This is a single violation.
Come up, Miss Castillo.
It's the first time we've ever had any issue with her.
So-
We'll say I talked to her right after she learned that she tested positive. She sounded really sick. She sent me pictures of the NyQuil that she was taking that had alcohol. And Judge, I'm not gonna sit here and insult your intelligence and try and say that that's what it was. I'm not gonna do that, but
If you ever test positive again, I'm now amending your bond conditions to put a leg monitor on you so I know that you're not consuming alcohol. If you ever test positive again, I don't care what it is, I don't care what anyone told you, you know and you should know what you're putting in your body. I don't care what the excuse is. But if I find that you test positive, you have any more bond violations, I'm gonna lock you up. That's it. Do you understand? Okay, so I'm amending your bond condition, put a scram on her ankle now, and I'll pay for it. Yeah. I want to make sure she's not consuming. If after a while she's not using, then we can talk, but I'm not going to take her word for it. We did that now. And where did it get us? So now I need more physical proof that she's not going to use. So now you're going to have a very cumbersome ankle monitor. You're going to have to explain to everybody what it is. Hopefully.
Let's pause here. This is the moment most people underestimate. When an officer smells alcohol or weed, they're not guessing. They're acting on legal probable cause. Question for you. Should one past mistake give them the right to assume guilt every time? Drop your thoughts below.
Get that. But court orders are court orders. And that's it. You're supposed to follow. And you don't, there are dire consequences. The next time, you're going to stay with me. You understand? Okay? Here we go. I'll pay for it.
okay.
And then here we are.
All right then.
All right, Colin. So we'll just do a normal setting, whatever you want, you know? Sure, yeah, absolutely. But
We're able to sit down and go through.
understand, it's no tolerance at this point. If I get another positive, if you fail to charge it like you're supposed to, if the battery goes dead, so does the bond. You understand? Okay? All right, Colin. Good luck.
Very clear, Judge. Thank you.
All right. Please. Are you Miss Alani Jones? I'm sorry, Alani Keontae Gonzalez.
Yes, yes.
Miss Gonzalez, your lawyer's asking me to set you a bond. You are a fugitive from justice. There's another state that wants you. I don't know why. I know that you're going to tell me it's little bunnies jumping in the woods, but I have to get to know you in a very short period of time. So please, let's get to meet Miss Gonzalez.
Your Honor, Ms. Gonzalez is one out of the state of Louisiana, specifically Baton Rouge Parish, for 2 offenses, the first felony larceny and the second monetary instrument abuse. I don't see that there's a bond there. She has no holds out of any other jurisdictions, Your Honor.
Any other criminal history? Okay. How old is she? How old are you, ma'am?
23.
You're 23?
And Judge, yes, that is true. She has no criminal history. She is indicating to me that she lives in Houston. She works in Houston. She has no recollection of even going to this parish. I've explained to her that you will give her 14 days if you give her a bond to go down there and settle this matter. We have no information about the case that we can give to her. She needs to go to Louisiana and handle that. She understands that. She's never been in trouble, never been in jail. She's asking for you to set her a bond so her family can bond her out and assist her in getting to Louisiana to address these issues.
I'm okay with giving her a bond. I mean, it's nonviolent. I don't have any, significant criminal history.
I'm not opposed.
So Next question is how much? Amy? Guys, what do you say? What do you think?
6% unopposed to a bond, but we'd be opposed to a low one. Maybe like 5,000. Maybe.
Judge, I would ask for $1,500. She's 23 years old. She works at a bar, on tips. Her family is willing to assist her. But I do believe that based on that information alone, that she's willing to do the right things, go and report back because she knows that you will issue a warrant for her arrest and bring her right back in the event that she does not obey these court's orders.
Ms. Gonzalez, you need to understand.
As a 3-year-old, she wanted me to.
You need to understand that these are serious charges and we take these really, really serious, you know? If you want me to set you a bond, I will. I'll set your bond at $1,500, but you have to understand that you're going to have to probably pony up all of that money. It's not the 10% deal because you're a fugitive, meaning you are a flight risk in and of itself because it's out of another state. I will give you the opportunity to bond out, but I want you to understand we don't play games here. So if from the day that you're released, we give you 2 weeks to go turn yourself in to Baton Rouge and take care of the business that you have there. You have to turn yourself in. There's no bond to post there. If you fail to do that, I'm going to revoke this bond. I'm going to set it at 0. I'm not going to give you another one. So if you fail to do it, I'm going to get you back because you can't run forever. And this time I'm going to hold you in custody until Baton Rouge comes and picks you up.
Okay.
You understand?
Yes, sir.
Okay. All right. So we'll set bond at $1,500 and then,
I will add she's waived, so she'll be needing to, or withdraw her waiver tonight.
okay. So she did waive.
Correct, on the other.
Have you spoken to any family members to make sure that they can make that bond?
No, Judge, I have
Okay,
not.
so the deal is this, is that, you know, we give them 14 days to come pick you up, 14 days from the day that you waive. When did she waive?
Yesterday.
She waived today?
Yesterday.
Yes, so you have 1 day credit toward that 14 days. When you have to withdraw that waiver to be able to bond out. You lose that 1 day credit. And so that's why I would like, you know, prior to you withdrawing that waiver, let Shibli reach out to your family to make sure they can make that bond because I don't want you to lose that 1 day credit, you know?
Okay.
So we can put you back once you verify, or if you don't want to, that's okay too. If you know that they're going to bond you out regardless. I don't know. Sorry?
I can go call them right now.
Well, give the number to Shibli and Shibli can call back there for you and then you guys can talk back there. Okay? And then just let me know.
Yes.
Thanks. Around and around and around and around we have gone. One case, and now a second case, and now we have a bond violation.
Yes, Your Honor. I had spoken with my client on January 18th, the family reunion. My client had ordered an Uber. The Uber canceled on him at about 8:40. And so he was going to order another Uber. His mother asked him not to do that. She said that she would take him home. And they ended up, there was a Yara. I'm not sure if I'm saying that right. But after that was over, then his mother took him home. That is why he arrived. That one day, his mother was here. He didn't have any questions for that.
Is that mom there?
Yes.
She speak English? And I'm not going to have you translate.
But Your Honor, he has had no other violations. He has 1 day of community service left on his PTI, and he is also currently working and should have the rest of the money for the restitution, which is $1,000.
This is what we're going to do. I'm sending him for a drug and alcohol test right now. I want to know what, if anything, is in his system. And then we're going to go from there. So I'm sending you now for a drug test. And then let's just put it on for tomorrow. I want to know what the drug test, if anything, is going to say. Or can you be here tomorrow?
Yes, Your Honor.
Okay. I'm sending you for a drug test now, and then you're up here, right back here, so we can redo everything and see. It's unacceptable. You know what the rule is. You're under strict compliance with 2 cases that are open. This is not the first bond violation that we've had. I'm extremely upset with you, Mr. Gonzalez. I'm not taking any action now, but I want to see what the test says and we'll go forward tomorrow. Okay?
Okay. You want him to come back today? After
Tomorrow.
Okay.
I'm sending you for a drug and alcohol test right now. If you fail the test, if you fail to go, I'm going to revoke your bond. I want you back here tomorrow and I want to see what the results are and we'll go.
Now this is where Judge Fleischer draws the line, and you can feel it. His tone isn't about punishment, it's about exhaustion. Imagine seeing the same person repeat the same offense again and again. Would you lose patience too? Let's be honest.
Forward from there. Okay?
There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January, her being, I think, either 14 or 17 minutes late, I guess the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow. And everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in the social setting. And recognizing that it was just craziness, she had to take her there first. Lines along, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15?
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. I will give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel. We're good to go.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least giving some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
So luckily we have that going.
Well, yeah.
Have someone to watch the kids.
Yeah, and that was for just about 30 days or so. Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st. Excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that, you know, these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend, is it occupational therapy? Speech, and occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of, my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, you know, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, you know, I don't want to portray myself as an expert in this at all, because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other. And so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. You know, they're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated. But all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here are, they're up there.
How high are we talking?
Hi, Your Honor. You know.
Standpoint, very large.
Yes, Judge.
Yeah, no, and you know, I understand, and that is.
You realize that most people at that level, you know, 0.4 is dead.
That's right.
Right? You're at a 0.4, you're dead. A normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Oh, absolutely.
Right? And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow.
This is where it all ties together. The judge isn't just ruling, he's trusting the system to fix what punishment alone can't. It's a rare glimpse of justice mixed with humanity. What do you think? Should accountability ever outweigh empathy?
The recommendation, because that's why we have these people. They're clinicians, they're experts in what they do. They make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. You know, I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it?
2.8.
A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
you know, and again, I know that
I understand. I'm never going to be
attributed
a lawyer for, you know, zealously advocating, and I appreciate it. And, you know, you have to do what you have to do. I understand. Sorry. That's just, it's too much. You know, if it was a 0.4 or a 0.14, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. You know, we can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, you know, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
You know, Your Honor, I absolutely agree that, you know, you know, when we're talking about treatment, you know, who can speak against that? And I do understand that.
And I mean, we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for a treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the keys program and the access program that, not really.
No, she's a .31 and a .28, really. That needs a lot. That's why they recommended it. And I'm sorry, but, I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is, your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. I'll give you another 30-day setting. But that's it.
Your Honor, would we bid in 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for the
I will give it to you, but that's it. I mean, really,
I get it.
at the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.
Yes.
Mr. Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So, correct me if I'm wrong, that he was out on bond on this case, right?
Judge, I'm not.
Yeah, we gave him a general bond and he failed to appear. Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back, and when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant, we revoked the bond, you ended up going back to jail, and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually putting on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
The GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB,
Correct.
so you don't think there's PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Standard sobrieties were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was red and the defendant considered a breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. So what's your argument?
So Judge, my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes, Judge.
The stop was initially because it's a prohibited vehicle, right? You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, 0.065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a 0.08 at the time that he was driving without any type of scientific method or any type of legal scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a 0.08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial. I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 6 out of 6 HGN, 4 out of 8 walking turn, and 3 out of 4 one-leg stand.
Right, so I think that there's enough just to go forward for probable cause purposes. Now, set it, you know, you may be right as far as they make, you know, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, what, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, you know, it coincides and.
Just to understand, I have to wait 30 days to set it, or I can?
No. You know, let them know now so that they can get their ducks in a row as far as subpoenas and all that, you know, and is the breath, is what discovery's in.
Yes, and it's completed, yes, you have. We're just missing station video, but everything else.
Okay, that's a big part, you know, because you're going to need that as far as breath testing and stuff. So, I mean, just stay on top of it. If you want to set it now,
Yes,
you
Judge.
can. If you want us to get a couple of weeks just to see if you can get the video,
I think
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge. Have a good one.